just common knowledge among most everybody in the world, obviously not to the Secretary, how can you then explain to me this Marine's mistake in taking classified documents or mishandling them is more severe than the Secretary of State who sent and received classified emails on a regular basis, including those that were originally classified, not those that were classified later, but were originally classified?
Yeah, first of all, I'm familiar with the case, and I'm quite certain it's not a 793F case. It was prosecuted
His
as
conviction was under 793F.
Yeah, I don't think, I mean, I'll go back and check again. I'd urge you to, too. I'm pretty sure it's not under the gross negligence prong of 793F. But it's a Uniform Court of Military Justice prosecution, not by the Department of Justice, am I remembering correctly?
This was from and is appealed out in the U.S. the Court of Appeals for the Armed Forces did actually hold it on this. Yes.
But regardless, I think even I don't think this is under the same provision, but even there, that's a case involving someone who actually stole classified information, hard copies. What people need to remember, and I don't say this to make a little of it, I think it's a very serious matter. What happened here is the Secretary used an unclassified email system, her personal system, to conduct her business.
And let's just stop right there. That in and of itself, and I understand it's Dr. Cummings, we've been through it, you've been through a lot of questions, I apologize. But let's just come back to the basics here. We're trying to parse that I didn't have such a Sandy Berger or all these others who've been prosecuted, they took a hard copy. In today's society, and even understanding if you go through any information,
that is not credible given the timeline where you have the New York Times saying that this server existed, the House immediately sends a subpoena, he has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where he has, these things are now under a subpoena, and he has conversations with people who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why did you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
By Congress, and only in spite of Reddit's own senior, what they call flak team, trying to hide it, only because a few people caught it, do we even know about it, and is this and other committees interested in getting the backups that may exist on these deletions? I guess my question to you is he destroying evidence relevant to congressional inquiries? And I'll answer it for you, yes, he is. And what are you going to do about it?
That's not something I can comment on.
Well, let me go into something that concerns this body in a very specific way. As a former chairman issuing subpoenas, I issued a subpoena, and additionally I issued preserved letters. In addition to that, now Chairman Chaffetz issued what were effectively preserved letters. Some of them were directly to Hillary Rodham Clinton while she was still Secretary. Others, the subpoena in 2013 was to Secretary Kerry. These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay. For the record, yes. The Department of Justice does not grant immunity without checking with federal law enforcement to see whether it will impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were granting, handing out like candy, according to some, immunity. Did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Cabetta. You gave them immunity from destruction.
Yeah, I don't think, well, again, I could always be wrong, but I don't have them in front of me either.
Well, because you don't let us take them out of the skiff, it's a little hard for us too. But the fact is, when you read them...
my answer? I'm pretty sure that what was granted was use immunity. In the case of those 2 people, coextensive with 18 U.S.C. 6001, which means no statement you make can be used against you directly or indirectly. Transactional immunity is sometimes given also by prosecutors, says you will not be prosecuted in any event for this set of facts. I don't think there was any transactional immunity.
Well, when I read for both of the attorneys that immunity was granted, it's in both cases said destruction, in addition to the turning over. Why was that? Why would you believe that was necessary, or do you believe that would be necessary? You wanted the document. You wanted the physical evidence. Why did you have to give them immunity from destruction of materials? And because my time is expiring, when you look into it and hopefully get back to this committee, I'd like to know, does that immunity apply only to destruction on the computers delivered so that other destructions by Cheryl Mills could still be prosecuted?
Yeah, again, my recollection is no transactional immunity was given. A protection of statements was given to the Cabetta guy and Mr. Pagliano.
Thank you, Mr. Chairman.
Chair, thanks, gentlemen. Recognize the gentleman from Tennessee, Mr. Cohen.
Mr. Chairman, I would ask unanimous consent quickly that a group of documents be included, and I'll summarize them. They're basically the letters and subpoenas that led up to the destruction of documents that were previously held for preservation. Additionally, the blog post from Reddit, if those could all be placed to the record.
Without objection, they will be made a part of the record.
Thank you, Mr. Chairman.
Tennessee is recognized.
Thank you, sir. Director Comey, would you consider the FBI's most important job presently fighting terrorism and threats to the homeland?
Yes, that's our top priority.
How much time do you think the FBI and you have spent responding to congressional inquiries and on this particular email investigation? Could you give me an idea how many months or years have been expended on responding to the different committees that have called you in time after time after time and repetitiously accused you of doing politics rather than being an FBI director?
I can't. I don't have any sense our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And you have, because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI.